in the appeal, R&S Pilling and UK Insurance Limited.
Ladies and Lords, I appear for the appellant with Mr. Patrick Vincent, my learned friend, Mr. Colin Edelman, and Mr. Richard Harrison represent the respondent.
And could I, at the outset, ask you, please, to make sure that you speak up?
I will.
These microphones are purely for transmitting to the big wide world what you are saying. They don't actually assist hearing in this courtroom. So,
well, I hope my lady can hear me now. If
I can hear you now. Yes.
Well, I will.
And I know what your name is, Mr. Eckland.
I will attempt to keep it at that level.
Thank you.
My lady, can I just first of all deal with one or two broad submissions before I get into the detail. The first is that in our submission there is no legitimate construction of this insurance contract that results in it indemnifying Mr. Holden for this liability. As written, it doesn't cover the liability. As construed by the single judge, it doesn't provide an indemnity. And the Court of Appeal's interpretation of the contract is not legitimate, and even if it is, we do not accept that their interpretation results in cover, because we do not accept that this was not a liability involving the vehicle. And we use the word involving deliberately there to contrast the situation with the well-known case of War Boys. And I'll give you the reference to that. It's in our bundle at tab 13, MS 648. That in that case, his use of the taxi in which women were assaulted was not regarded as being something which involved his taxi. And we say, if in that case his taxi was not involved, then it's very difficult to see how, in this case, repairing of a vehicle could result in a decision that the vehicle was involved. Second, there's no legitimate construction of the Road Traffic Act, 1988, that results in it requiring cover for this sort of liability, whether on or off a road. For many years, the purpose of the RTA, and we start in 1930, go through to 1972, and then 1988, and then an amendment in 2000, when public places was added to the requirement for cover on roads. For many years, the purpose of the RTA has been to implement the motor insurance directives, and if assistance is needed, it is to Europe that this court should look, not the Commonwealth authorities, as my learned friends will submit to you. Neither the motor insurance directives nor the decisions of the European Court support the broad proper interpretation and proposition of the respondent and the Court of Appeal. And lastly, as a matter of general observation, it's not the policy we submit of the statute, the Road Traffic Act, to protect the public from negligent repairers, or in this context, welders or grinders undertaking repair work to motor vehicles in private premises off-road. The consequences of their actions are best underwritten by public liability insurers, such as the respondent, which have the opportunity to assess that type of risk. And it won't have escaped my lady's attention that this is a battle between motor insurers and public liability insurers.
We had understood that.
You'd understand, I'm sure you had.
Yes.
So those are three broad submissions. Can I then just identify our rather more specific submissions, taking the contract and the judges, the judgments in the Court of Appeal. The first on the issue of construction. And I think on both sides here, we accept that at the end of the day, this is perhaps a matter of impression for a court and for a judge. And we don't intend, I think neither of us intend to bedevil you with the authority which one of you, I think, has written. So we will accept, I think, what's indicated in one of the cases, that we don't need to address you on the authorities. But on the first issue of construction, we submit that the Court of Appeal was wrong to remove the condition in Clause 1A on which the express policy cover is based. And if you look at the judgment at paragraph 49, at page MS 148, you will see that what the Master of the Rolls did was to remove the express condition that Mr. Holden be in the car at the time of the accident. When we come to look at the policy, you'll see that that is the removal of the only condition which attracts liability under the express terms of this policy. And in our submission, that was amendment of the policy, not interpretation. The second specific submission we make is that the Court of Appeal was wrong then to treat the remaining cover as being cover for any incident which involved Mr. Holden's vehicle. And if you look at the judgment, you will see that at paragraph 42, the court has concluded in the last line that the error in the language of clause 1A that it assumes can be rectified in effect if there is an accident, by restating that to be if there is an accident involving your vehicle. We submit that neither the statutory cover nor the express cover could justify that conclusion, and His Honour Judge Waxman QC rejected that conclusion because it did not reflect the language of the statute, namely section 1453. And can I show you that? It's at paragraph 23 and 24 of his judgment at MS 163. Where at the top of page he says, a better wording would be, if there is an accident involving your vehicle. But then he goes on to say, but at this point one needs to take account of the words used in 1453A of the Act. This refers to liability for damage, etc., caused by arising out of the use of the vehicle, and clause 1A must comply with this. So he says in paragraph 24, in my judgment, therefore, the proper construction of the initial part of clause 1A is, we will cover you for your legal responsibility if there is an accident caused by or arising out of your use of your vehicle and you kill or injure someone.
Without the geographical limitation.
Without the geographical limitation.
So you say in paragraph 42, the Court of Appeal adopted part of what Judge Waxman was saying, but didn't have regard to his qualification.
Correct.
Yes, because he was talking about a policy where the accident was caused by the vehicle rather than simply involved the vehicle.
Yes.
So are you conceding that in our interpretation of the booklet, we should look at and be informed by section 145.3?
Indeed. And there is a specific reason for that, my lord, and that is that the policy itself certifies, and I'll show you this.
Well, of course.
I take the of course to accept that. Then the policy certifies, on the one hand, that the policy complies with the provisions of section 1453. It's not disputed between us that that happens always in motor insurance policies because it's a requirement of the regulations.
But what you accept is that we have to read clause 1 in that light.
No, I don't necessarily...
That's what we're getting at, I think.
I'm sorry. I don't necessarily accept that. What I do accept is that you have to incorporate into the policy.
Yeah.
Well, that was,
Yes.
we all know about that.
Yes.
Yes.
But I thought that your first point was, actually, Section 145 doesn't add anything, because that is simply on-road, and we're not talking about on-road here, so it's back to the booklet.
No.
So that was what lay behind my question. Are you saying that the booklet's construction should be informed by the Act?
Yes, I do. Yes, I do.
You do?
Yes.
But only to the extent of actually incorporating the cover required by Section 145 into the cover
Yes.
policy, not interpreting the words of Clause 1A.
No, exactly.
So you're
That's
not,
I think, what you're
I'm
saying.
getting at.
I know that's what you're getting at, but
so you don't support Judge Waxman in paragraphs 23 and
You don't
24,
actually support-
ultimately. You don't rewrite the clause 1A.
Ultimately, you're right, because what I submit is that the way in which it should have been rewritten is that it should have been rewritten in this way. We will cover you for your legal responsibility if there is an accident caused by arising out of your vehicle on a road or other public place. That then incorporates the Section 1453 cover. And I would add, or if you have an accident in your vehicle and you kill or injure. And that reflects the express cover.
that's what I thought you were saying. So
Yes.
it's very important to be precise about this.
I'm sorry.
So may I just make sure I've got that down correctly? We will cover you if the accident
For your
is
legal
caused-
responsibility if there is an accident caused by or arising out of your vehicle on a road or other public place, and I would put in brackets there reflecting the statutory cover, or if you have an accident in your vehicle and you kill or injure, reflecting the express cover. Now,
So you have a two-part
yes,
cover.
and the effect of that is that the statutory cover, of course, is limited to a road or other public place. That has to be provided. And the extension reflecting the express cover recognises that the cover goes beyond a road or other public place in circumstances when Mr. Holden was in his vehicle, because that's what the express cover says. So that gives meaning and sense to the express cover and to the statutory cover, which of course is incorporated in the policy. Now, the next observation I wish to make is that the Court of Appeal's treatment of or in construction of the scope of cover was based, wrongly we submit, on its conclusion that something had gone wrong with the wording of the policy. That's paragraph 42. MS 147, because the express cover provision did not track the terms of section 1453. And we see that from paragraph 48, where the Master of the Rolls refers to the fact that the language of the express cover doesn't track the language of the policy. I beg your pardon, the language of the statute.
Do we know whether there are any other standard form motor insurance policies that have express cover in the same terms as this one?
We haven't researched that. I don't know the answer to that.
Hope not. I said we hope not, because it was so badly drawn, wasn't it, Mr. Eklund?
Well, I'm not sure that it's for me to comment.
Isn't it? Very well.
Not sure it's for me to comment on that. But what one can say is that it is possible to identify the true scope of the cover if one has regard to the statutory cover which is incorporated and the specific cover which is provided. I can see that there might be other ways of writing it in a more felicitous way, but actually when one looks at it carefully, one can see the scope of the cover. And it's quite extensive. If one thinks about it for a moment, it's as extensive as the statute requires, because it provides the on-road cover, and it provides cover off-road as well when someone is in a vehicle. So the only lacuna, as it were, is the small amount of, it doesn't provide cover when someone is off-road but not in their vehicle. Think about what, and the circumstances which immediately come to mind are the vehicle which is left and might roll down a hill in a paddock or something like that, where somebody gets into it, a child gets into it, the traditional explanations, the child gets into it and fiddles with the handbrake and the vehicle rides down the hill, or it hasn't been parked properly, or it has been parked in a dangerous place and someone has left the vehicle. So the scope of cover actually is very wide. So we submit that this appeal should be allowed on the basis of formulating the scope of cover as I've tried to explain to my lady and to your lords, because it's clear that the actual circumstances, of course, do not fit, do not come within that scope of cover, because Mr. Holden clearly wasn't in his vehicle at the relevant time. Now, the second category of submissions which I want to deal with briefly is the question of repairs. And I submit that the Court of Appeal was wrong to conclude that the repairs were use of the car. And the Court of Appeal's findings in relation to that are in paragraphs 53, 59, 69, 75 and 76. Your lady and your lordships may have picked up in your reading that there's no English authority which supports that conclusion. We submit that the guidance provided by European authority in relation to the meaning of use in the Motor Insurance Directive indicates that use is something which is consistent with the normal function of the vehicle. That's Vanook, which we'll come to, and as further qualified as a means of transport. That's Andrade, which we'll come to. The statutory requirement should be construed and interpreted, we submit, as far as possible in accordance with the directive, so long as it does not go against the grain of the directive. And in our submission, grinding and welding a vehicle with its battery removed whilst it is supported by a forklift truck on one side is not the normal function of a vehicle as a means of transport. Far from functioning, the vehicle was disabled from functioning. Grinding and welding constituted, in our submission, doing something to the vehicle, not the functioning of the vehicle.
Something preparatory to?
I beg your pardon?
Something preparatory to use?
Something preparatory to use, certainly. Certainly. And Judge Waxman recognized that vehicles are repaired. And obviously we recognize that vehicles are repaired. But the statute, of course, has never extended the requirement for cover specifically to repairs. There are other statutes which deal with that specifically, and nor has it ever extended the obligation for cover beyond a road or other public place.
So do you go so far as to say repairing is not using?
I do. And in our submission, this court should follow the European guidance, since it was interpreting the meaning of use in the European context, where compulsory liability insurance for motor vehicles is mandated by the directive and use is included in the Road Traffic Act, which reflects and responds to the directive. The Commonwealth authorities on repairs reflect different insurance and statutory regimes. We submit that the requirement that use should be an autonomous concept of European law is a powerful reason for aligning UK law with European law and not Commonwealth law. And further, we submit that Mr. the judge was correct in paragraph 60 of his judgment, MS 169, to conclude that repair did not amount to use of the vehicle without more, and he drew the distinction that if the vehicle had then been driven to test a repair, that would have been a different matter, because then the vehicle would have been operating in the usual way. And he was obviously considering the position when we knew of Vanook, or Vanook had been decided. He was not considering the position at the time that Andrade itself had been decided. So we submit that the appeal should be allowed on that basis also, namely that the repairs did not constitute use of the vehicle so as to fall within the statutory requirement. The next point is that in our submission, the Court of Appeal was wrong to find that damage resulting from the repair arose out of the use of the car because it was, in a relevant causal sense, a contributing factor. And the paragraphs for the judgment in the Court of Appeal for that proposition are paragraph 69, 75, and 76. In our submission, the Court of Appeal ought to have found that the damage arose out of the introduction of an ignition source to the immobilized car. In such circumstances, the car was a casual concomitant in the damage arising, only a contributing factor, we submit, in a but-for sense, but it did not have not in any causal sense. And I've already referred to the case of War Boys, where the policy itself covered circumstances involving Mr. Warboy's vehicle, and Mr. Justice Silber decided that assaulting women in the back of his car did not come within that category in our submission.
Despite the fact that it was a taxi was a large part of the reason why they were in the car in the first place.
Indeed. And finally, just to draw these submissions to a close, His Honour Judge Waxman, you see, was correct to find that the fire was caused by and arose out of the allegedly negligent repair of the car by the use of grinders and welders, and did not arise out of the use of the car. See paragraph 66 at MS 170. And in that context, he was right to reject the contention that either because there had been prior driving into the garage, or there would be prior driving, or there would be subsequent driving, that the damage arose out of the use of the vehicle. A submission had been made to him because the vehicle had been driven into the garage and then was going to be driven out again, that could therefore amount to arising out of the use of the vehicle. And he, in our submission, rightly rejected that.
Let me get my head around this.
Yes.
Is it the consequence of the approach adopted by the Court of Appeal that if I take my car to be repaired by a garage, and therefore obviously allow the people in the garage to drive the car in and out of the repair shop or whatever, and they do something negligent, as a result of which massive damage is caused either to persons or property, it's my motor insurers who have to cover that damage rather than the garage's liability insurers?
Well, I think the answer to that is probably yes.
It's clause 2.
That's clause.
It's the extension. It's the extension in clause 2. If it is repairers driving to and from.
Yes.
But your point, I imagine, is that what clause 2 doesn't extend to is the mechanics carrying out repairs.
Yes, I would say that. But along on that line of thinking, what the Court of Appeal appears to have done is to identify repairs as a matter which is the use of a vehicle, and therefore almost automatically, because it's the use of a vehicle, requires cover to be extended to it. And we would say that is wrong.
Well, you would also say that has massive implications for the motor insurance industry, wouldn't you?
Indeed. So can I then turn to one or two of the documents and deal with policy construction? And I'm sure that you will have seen these, but so I will take it quickly. But first of all, the policy certificate itself, which you will find at Appendix 285, I beg your pardon, 286 at MS 419. Now, this certificate is in the form that is required by regulation. I won't take you to it, but I'll just give you the reference. It's an Authorities Bundle 1 at tab 5 at MS 502. So it's a certificate which has to be provided. And it's in familiar form, certificate of motor insurance, etc. The relevant parts are in the fifth box down, limitations as to use for social, domestic and pleasure purposes. And we would submit that repairing a vehicle doesn't amount to a social or a domestic or a pleasure purpose. And second, the policy does not cover a number of different things used for racing, competitions, rallies, trials, track days, and so on. So what the first point to draw to your attention is that statutory cover does not mean absolutely broad cover of everything. Here immediately we see a limitation on the use of the vehicle to social, domestic and pleasure purposes. Some of the other purposes will be familiar to the court. Business is one. Using your car as a commuting vehicle has become another. So the first point is that a certificate may limit the scope of cover so that the statutory cover is not wholly, absolutely everything. Second, certification. I hereby certify that the policy to which this certificate relates satisfy the requirements of the relevant law applicable in Great Britain. And that is by that certification and its common ground, that incorporates the statutory cover in section 1453. And just to look over the page, on the same, just across the page at 287 for a moment, the motor proposal confirmation. This was a policy which was arranged online. And the request for cover, you'll see under policy details, period of cover, comprehensive, that's third party and liability cover, use, social, domestic and pleasure cover was what was requested. Now, the policy itself, the express clause which we're concerned about, you'll find at page 257 in that bundle.
MS?
I beg your pardon, 390. Section A, liability to other people. We will cover you for your legal responsibility if you have an accident in your vehicle. Now, it's that condition, and that is the only condition of cover under the express term. It is that condition which the Court of Appeal removed, and we say wrongly. The second point about that is that you'll notice that it doesn't have a geographic limitation, and we accept that. But the effect of the Court of Appeal's judgment is to remove the limitation or the condition on the one hand, but to retain the lack of any geographic limitation on the other. And we submit that that is quite wrong. That's not interpretation of a policy, that's amendment of a policy. And it's picking and choosing, because it takes away the express form of cover, whilst at the same time leaving the implied scope of cover. And in our submission, once you take away the express form of cover under clause 1A, all you're left with is the statutory cover. But if you retain the geographic implication of the express cover, you are then left with the statutory cover, but extended beyond a road or other public place. And we submit that as wrong. That as a matter of construction, you can't pick and choose, but you certainly can't amend the policy. You must interpret it. And you can interpret this policy accurately and to find the accurate scope and quite considerable scope of the policy, as I indicated to you earlier, by reflecting the statutory cover and reflecting the express cover.
You seem to be putting page 390 away, are you?
I was.
I mean, do we get any assistance in construing 1A from 2, cover for other people, Mr. Eklund?
My Lord, I submit you don't. One can read the other cover, but if we just go through them, anyone insured by this policy to drive your vehicle, as long as they have your permission, that doesn't assist, because we accept that we're dealing with use of a vehicle. Drive your vehicle has a more limited meaning than just use on the authorities. Anyone you allow to use but not drive your vehicle for social or domestic purposes. We don't see how that assists in interpreting what the limit of liability is for the insured.
What's that gunning at? Would that be sitting in the back of your car having a cup of coffee? Or?
Well, it must be something like that.
Yes. Yes.
It must be something like that. Anyone who's getting into or out of your vehicle, that's actually a response to the Brown and Roberts decision, which we may or may not need to come to.
It was that bullet point in particular that led to my question and led me to wonder whether the reference to in your vehicle in 1A has to be read at least slightly more broadly than it might otherwise be, Mr. Eklund.
Well,
because it covers people getting in and out.
Well, the genesis of that clause is case of Brown and Roberts. I'll give you the reference if we need to go to it, in which the decision of the court was that someone who was a passenger and who opened the door of a car onto a pedestrian was not using the vehicle. And so that clause now turns up in motor insurance policies from time to time. But it doesn't, in our submission, give rise to a conclusion that the cover or the extent of cover for the insured himself must be broader. He will be getting in and out of his vehicle. He will be doing that on a road or other public place most of the time. He will be covered if he's getting in and out of his vehicle on a road or other public place. And the limitation would only amount if one was to think that one had to extend the scope of 1A to reflect the point that my Lord has asked about. The limitation would only arise when he's out of his car and getting into and out of it, and in any view wouldn't cover the circumstances of this case.
I'm sorry, earlier when I mentioned section 2, what I was referring to, as you have realised, was the exception from the general exception, but you'll be coming to that later, maybe. This is where I said that
the repairer.
The repairer.
Yes.
The repairer is allowed to drive and use it for purposes. But,
Yes.
It's not being suggested there that the repairer is covered for the repairs he carries out.
No. So we submit that the policy provided what it required to provide by statute, and additional cover. That additional cover comprised part of the bargain. It is in clear language, and it doesn't require to be amended to be made sense of, as the Court of Appeal did. We submit that no further construction is necessary. It's common ground that the incident circumstances do not come within the circumstances of cover provided by the language of the policy. The respondent is forced to say that the policy cover should be interpreted more widely, and in effect it wants section 1453 cover, but without any geographic limitation. It wants to, in our submission, ignore the express terms of the cover in clause 1A, requiring the insured to be in his vehicle, but embrace the absence of any geographic limitation in that express cover, so that the remaining section 145 cover is unlimited geographically.
The problem in your submission, as I understand you, is that the Court of Appeal has tried to make a sort of amalgam of the two.
Yes, wrongly.
You say that they sit quite happily side by side.
They do.
And you take both.
Yes.
Rather than trying to merge them into some composite.
Indeed. I then look to see whether there is any other principle which we should, in principle of interpretation, which should undermine the submission that I've made, that, and picking up my Lord Kitchen's point, that you see the two strands of cover side by side, whether there's any other principle of construction, and which should undermine that submission. And in my submission, there is none. And if I can just make some points in relation to that. First of all, the natural and ordinary meaning of the language of the certificate of motor insurance is clear and incorporates the statutory cover. That's not in dispute. It incorporates it subject to the limitations in the certificate, limitations of use as to social, domestic and pleasure purposes. The second is that the natural and ordinary meaning of clause 1 is clear. The third is that the context and reason for the cover is statutorily required cover. We bear in mind that providing only the statutory cover, the section 1453 cover, would suffice, although it might not be a policy which would compete in the present market, because many drivers, many owners would want to have more extensive cover and could find it with another insurer. But nevertheless, the context and the reason for cover is essentially the need to be able to drive a car, use a car legitimately, legally on a road or other public place. We submit that if a reasonable person having all the background knowledge which would have been available to the parties had looked at this policy, they would have understood the language in the contract to mean as we submit. There is a specific provision in the policy cover can be provided under those circumstances. There is a certificate in the policy, and cover can be provided under those circumstances. That cover is extensive. The only evidence of any background knowledge which can be relevant on the facts of this case is that Mr. Holden, as a consumer or user of a motor vehicle, required compulsory insurance to be able to drive his vehicle legitimately. And UKI, the insurers, were providing such insurance and such additional cover. We don't have any evidence from Mr. Holden of any other intent or any intent to get any cover more widely expressed than that. In our submission, there's no ambiguity here. There's no ambiguity by the incorporation of the Section 1453 cover. That is what is required. It's well known that all policies include it. Respondents agree with that. You see that in paragraph 120 of their statement of case at MS 125.
Can I ask, Mr. Eklund, is this the way you put the case to the Court of Appeal? Because I don't really see it reflected in paragraph 36 of the Court of Appeal's judgment. The Court of Appeal deal with the arguments from paragraphs 35 and 36.
Yes. No, I accept that I didn't put it as precisely as I'm putting it now, that there are two strands of cover. I think we all got, right from the time that we were dealing with this before the judge, all got involved in trying to find a form of words which drew the two strands together. And I accept that I didn't put it in this way. But I hope I'm putting it correctly now, because I think with having had the opportunity to reflect on it, it is the correct construction of this policy, and certainly doesn't amend the policy in the way the Court of Appeal came to conclude that it should be amended as we submit as wrong. So I was submitting that there's no ambiguity by the incorporation of the Section 1453 cover. In our submission, there's no ambiguity in the language of the Clause 1A cover or the scope of cover provided by it. The parties were free to agree on their bargain, which they did, including the limitation of cover to use, which is for social, domestic, or pleasure purposes. There's no evidence of any contrary intention which would undermine the conclusion that we ask you to accept. There's no evidence, for example, that there were circumstances of some form of agreement which would arise or allow an argument in rectification of the policy. We submit that to conclude that the policy cover should be extended to include accidents occurring off a road when the policyholder is not in the vehicle, would be to amend the policy, not to interpret it. And that is something which His Honour Judge Waxman, QC, was alive to. Although Clause 1A doesn't describe or expressly track the language of the statute, as referred to in paragraph 47 of the Court of Appeal judgment, MS 148. In our submission, it's not necessary for there to be a restatement of the provision of the statutorily required cover. That's already provided for by the certificate. And therefore,
the two-strand argument depends on treating the certificate as a separate form of cover rather than a statement of what the policy itself does.
I don't entirely accept that. The two-strand argument provides, first of all, recognition of the express cover, and second, recognition of the cover which is certified. And all I'm submitting to you is that you don't have to restate the cover which is certified to incorporate it into the policy, for it to be incorporated into the policy. It would be a strange conclusion if the certified cover wasn't found to be cover which is provided for under the policy. It's required by statute, it's required by the regulations, it's certified as being present in the cover itself. Then one looks at the express cover to see what else additionally is provided. The alternative way, which arrives at the same result, is you look at the express cover, and to the extent that it doesn't incorporate the statutory cover, you add the statutory cover to find the final scope of cover.
Well, the consumer, sorry.
Sorry, after you.
Well, the consumer would go to 1A to find out what the cover was.
Well,
I was only going to make the point that the policy itself, or the booklet itself, says your policy is made up of the motor proposal confirmation, this policy booklet, the certificate of motor insurance and the schedule.
yes,
So it expressly incorporates the certificate of motor insurance into the policy.
yes. And if you look at the certificate of motor insurance itself, also has a note right at the top of it. At MS 419. This certificate is evidence of your insurance. For full details of the cover, you should refer to the policy. And that particular statement is in fact a statement which is required by the regulation in the form that's attached to the regulation. It's MS 502 at 507.
So the certification at the bottom of the certificate, I hereby certify that the policy to which this certificate relates satisfies the requirements of the relevant law, Great Britain and Northern Ireland and so forth. You say actually incorporates the statutory
Yes,
requirements into the policy.
yes. Paragraph 42 of the Court of Appeal judgment, which I took you to earlier, the Master of the Rolls says something must have gone wrong with the language. What he had in mind was that the language didn't track the language of the statute. Our submission in response to that is, if the policy includes the statutorily required cover, as it does, and additional cover, as it does,
All of these problems fall away.
all these problems fall away. Nothing has gone wrong. It just doesn't extend to the circumstances of this case. Can I finally just summarise our position on this, and that is that no proper construction or interpretation of the combined effect of the liability to other people section of the policy, i.e. Section A, and the motor insurance certificate could properly first remove the express condition of cover, second, leave only the statutory section 1453 cover for liability, but amend and expand the effect of section 1453 by adopting the lack of reference to any geographic limitation in the express conditions of cover.
Depends which end you start. If you start with the lack of a geographical limitation, then on your interpretation, you're adding it in.
If you start with the lack of it, yes, exactly. And what the Court of Appeal has done, in effect, is to remove the express cover, which doesn't have a geographical limitation, to adopt the statutory cover, which does have a geographical limitation, but to then amend that to add the lack of a geographical limitation because of the express cover. And in our submission, wrong to do that. It's to pick and choose, and really is to amend the policy, not to interpret it. Sorry. Yes. And as Mr. Vincent reminds me, the Court of Appeal has in fact gone further by concluding that the cover should be described as cover which is involving the use of your vehicle, and on no view of the statute or of the express cover can one properly come to that conclusion. Unless I can help you with anything further in relation to the policy itself and construction of the policy, those are my submissions on the policy construction. So I turn then to the question of the second issue, and that is the issue of relevant use. And the first point that perhaps I'm going back to the certificate at MS 419, and we don't need to look at it, I don't think, but that identifies what use was covered under the policy. And contractually, use was limited to social, domestic, and pleasure purposes. It's a familiar limitation on the scope of cover. If the use does not comply with such use, then there is no cover. You're using your car. If Mr. Holden had been using his car for business purposes, he simply wouldn't be covered. Recognized that that is a time-honored limitation.
But if, when he conducted this repair, he was using it, do you accept that he was using it for social and domestic purposes?
Well, I don't know what purpose in that sense he was using it for. I don't know whether he was using it for a business purpose, preparing for a business purpose, preparing for commuting, preparing for social, preparing for what? In my submission, you cannot say that he was using it for any of those purposes if he was actually repairing his vehicle. And the reason for that, there is an underlying reason for that. And what the insurers are recognizing is that the risks are different for people using their vehicle for different types of purpose. And premiums vary accordingly, something which was acknowledged in Bristol Alliance by Lord Justice Ward, that there are legitimate restrictions on the scope of the use that can be given to a vehicle contractually. And I should point out also that there are other exclusions, they don't apply here. There are other exclusions and exceptions which can legitimately be applied to policies, so long as they are not exclusions or restrictions which are barred by statute. Now, the effect of that is that you might start with an overarching thought that the use is a very broad one and every use has to be covered. But in fact, by a series of restrictions and limitations, you can see that is not the case. So I submit that a repair is so alien to the concept of social, or at least, I won't put it quite so highlighted, but it is alien to the concept of business use, or social use, or domestic use, or commuting use, the sort of uses which are permitted, that you can't say that it fits within the scope of that limitation.
Does it not depend on the nature of the repair? I mean, for example, you get a puncture on the roadside, and you're using the car for domestic and social purposes, and you repair your car on the roadside. Would that cease to be for social and domestic purposes?
The reason that that's different is that you continue to use parts of your car, presumably. You've got a puncture and you replace your tyre to continue your journey. You're taking out of your car your tyre or your wheel, and you're putting it onto the vehicle. That is, one can see that if you were using your car in those circumstances for a domestic purpose, going to the supermarket or coming back from the supermarket, you could see that, and you can legitimately, I think, identify that as a continuation of the journey or part of the journey, which involves using a piece of your car to keep that journey, to maintain that journey. That, I think, is a different order altogether from taking a car off the road when you're not using the car then, driving it, using it in any sense.
I understand that. I was just testing the breadth of your submission.
Yes.
That a repair is necessarily not used for a social, domestic purpose.
They're of a completely different order.
Yes.
In my submission.
I note in his witness statement, Mr. Heldon says, I've never had reason to use my car for any purpose connected with my employment.
Yes.
I don't think it was ever suggested that he used this car while not insured. I don't think it was ever suggested, was it, that he used his car otherwise than within the limitation of the certificate?
My Lord, it's never been suggested that he was, when he was driving his car, that he was using it otherwise than as social, domestic, or pleasure purpose. No, that was never suggested.
No.
And that's not the point of my submission. The point of my submission is to identify that when you ask the question, was this a pleasure, domestic, or social purpose, you cannot say then that repairing something, taking it into a workshop and putting it on its side, or partially on its side, supported by a forklift truck with the battery disabled, that you're using your car for a social, domestic, or pleasure purpose, or indeed a business purpose.
I think my question actually broke it down. If this repair was use, was it used for social and domestic purposes?
Well, I'm sorry, I understand the question, but my answer is you can't tell.
Very well.
You can't tell.
No.
I mean, on the premise that your Lordship puts to me that it was never suggested to Mr. Holden that he used his vehicle for anything other than social, domestic, or pleasure, then I can see that the repair enables him to use his car for that purpose.
That's the preparatory point.
That's the preparatory point. But that's not actually the use for that purpose.
Very well.
I referred to Bristol and Alliance, and can I just give you the reference to that? It's paragraph 42 of Lord Justice Ward's judgment at MS 660. and then more specifically MS 667. And perhaps it's worthwhile just taking you to that. It's Bundle of Authorities at tab 15.
Page.
I beg your pardon, 667. Sorry, I may have the wrong reference.
Para 42 is 684, if it's...
664? 684.
It is paragraph 42 you were wanting to look at, is it? Don't think so.
That is at 684.
Yes, I'm not sure if that is right.
Which paragraph do you want?
I beg your pardon, I thought it was paragraph 8. It's 45. Yes, I beg your pardon, it's 45 at 684, I do apologise.
45.
That is at 684. Yeah.
684. What we see Lord Justice Ward doing there is to, having gone through the scheme of the Act, he concludes there is no exhaustive list of matters which cannot be excluded from the cover of the policy. Other exclusions are effective. Thus, the validity of time-honoured limitations on use, for example, for social, domestic or pleasure purposes, have never been doubted. If there is a social, domestic or pleasure limitation, then to use the vehicle insured in that way for hire or for business would be to use the vehicle illegally, because use for hire or business would not be covered by the policy, and the use for that purpose would be uninsured. That provides some confirmation that the identification of the actual use and the limitation of the use in the certificate is intended to have and is recognised as having a limiting effect on the cover which is provided by the policy.
And are you saying that it's unlikely that the policy covers repair because it is not possible to tell whether that is a business purpose or a social domestic pleasure purpose?
Well, I put it on two bases. First of all, that it is not a social, domestic or business purpose, or pleasure purpose in our case. And second, it is not, the point that my lady has just made, it's not possible to tell what sort of purpose it actually is. Now, moving on from that to the authorities. And the first point to observe, and it's uncontroversial, is that no previous case has grappled with the concept, no previous English case has grappled with the concept as to whether repairs to a motor vehicle amount to the use of a motor vehicle and fall within the permitted limitations of cover.
Is there any Scottish case?
We didn't find any. I'm not aware of any.
You looked?
We have looked. I think none of us has found any.
We always ask in this court, you know.
We always look. No, on a serious level, there is no English authority which grapples with this, which we would submit is perhaps some indication that nobody has ever thought that repairs to a vehicle carried out in this sort of way amount to use of the vehicle. And one goes back to thinking, if one thinks about the possibilities that there must have been over the years, since 1930, when compulsory insurance was brought in, compulsory motor insurance was brought into this country. Millions and millions of policies, the millions and millions of repairs that must have been carried out. I suspect it's not the first time that some damage has arisen to property as a result of a repair being undertaken to a vehicle. And it may be some indication that, in fact, nobody ever really does think that motor insurers should pick up this sort of liability. The starting point is Elliott and Gray, which is in the authorities at Bundle 2, tab 25, at MS 892. And the proposition, again, which is not controversial, which arises from this case, is that use has a broader meaning than just simply using or driving your car. This was a case of a vehicle which had been left on a road, and by leaving it been left on the road, the engine didn't work, the battery had been removed, and there was no petrol in the tank. And the court held that that still required the owner of the car to have insurance. And the reason for that was that the owner had the use of the car, even if he wasn't using it. It was a case which was brought against the owner as a criminal case, and defined the requirements when insurance was required. The second, in a similar line of authorities, is Pumbeen and Vines. That's in the same bundle at tab 31, MS 955. Here, the vehicle had been parked for 7 months. The rear brakes had seized, the tyres were deflated, and the gearbox had no oil. The case was not concerned with the scope of cover, but whether or not there was a requirement for cover when immobilised and not functioning.
Beg your pardon, I haven't got the page. The MS number?
The MS page is 955.
955, thank you. Thank you.
Now, those draw your attention to those two cases because they identify that the scope of cover can be, I beg your pardon, the definition of use in these circumstances is not just get in your car and drive it. It is one where you can have the control, you can have the use of your car by way of control or management. It takes account, obviously, of the possibility that your car drives down the road without you in it and causes some damage. Those cases are of limited effect in our submission. In this case, since what they do is to identify that the concept of use is not simply limited to use by driving or manoeuvring, but includes having the use of the vehicle.
Have we left Elliott and Gray?
Yes.
You probably noted the submission of the great James Miskin. Of course, he had a brief, and so we must look at argument with caution, but at the very bottom of 895...
Of 895?
895. You see his submission to the Divisional Court. Yet if the mechanic had been working on the car in a garage, he wouldn't have been using it. Of course, he was alleging that his client hadn't been using it in the circumstances of that case, and that submission was rejected. But I draw that to your attention if you had missed it, Mr. Eklund.
Thank you.
Yes?
And in our submission that those authorities don't assist the respondent. The control and management of Mr. Holden's vehicle had been brought to a non-negligent end when he took it into the workshop for work to be undertaken to it. Left in that location with the battery disconnected and raised by use of a forklift truck, there was certainly no use of the car, which was then negligent or which would cause damage. The car was an inert collection of materials at that point, which could not be used for any social, domestic, or pleasure purpose.
So Elliott and Pumbin are simply USAE cases interpreting what is meant by use of a vehicle on the road,
Yes.
on the road in a statutory context.
Yes.
Yes.
And in our submission, considerations of ordinary meaning, ordinary parlance, would not suggest that repairing a vehicle was using it. They're different concepts. If you repair a refrigerator so that it can chill your food, you're not using your refrigerator, you're repairing it. Similarly, if you repair a computer so that it can process your data, you're not using your computer, you're repairing it so that you can process your data. Now, I want to turn then to briefly to the respondent's argument, which is that this was an activity which was incidental or ancillary to driving the vehicle on a road or other public place, and therefore was using the vehicle. The summary of the respondent's submissions for your note at this point is in paragraph 129D of their case at MS 128. The argument is that because the repairs were incidental or ancillary to the driving on a road, therefore that amounts to use in the relevant sense. This was an argument which was essentially presented to His Honour Judge Waxman QC, as we see in paragraph 66 of his judgment. That's at MS 170. Where it had been pleaded in the defence that either because, and summarised by the judge, either because he had been driving it or because he drove it into the garage or because he drove it in near mats on the floor, which also caught fire, or because he would be driving it afterwards, and points of that kind, that amounted to use. And the judge concluded that that was an wholly artificial analysis. The fire was caused by and arose out of the allegedly negligent repair of the car by the use of grinders and welders. Now, in our submission, that is an accurate and succinct response to the suggestion that these repairs were incidental or ancillary to use on a road, and therefore support the respondent's submissions. Just to analyse the incidental or ancillary argument, it's based on Lord Denning's dissenting judgment in Romford and Lister Eyes. And the authorities, we have that in our authorities at Bundle 3, tab 34. at MS 1013, and in particular at MS 1029. Where we see in the passage at about halfway down the page, there's a paragraph beginning, Mr. Patrick O'Connor submitted.
Sorry, which page reference is this?
1029.
29, sorry.
1029.
Thank you.
1029.
I heard 39 and wondered why we were in
Yes.
a different judge. Thank you. Yep.
And he's just picking up at that paragraph. Mr. Patrick O'Connor submitted, however, that all this discussion about the Road Traffic Act was beside the mark, because this particular accident did not occur on a road but in a yard. I do not think that it can be put on one side in this fashion. Mr. Christopher Shawcross gave the correct answer when he pointed out that in order to comply with the Act, the motor policy had to cover injury to any person caused by or arising out of the user of the vehicle on a road. The injury to the father was not caused by the use of the lorry on a road, but it did, I think, arise out of it. The lorry was used for transport on roads, and in the ordinary course of its work, it had to pull into yards and forecourts and so forth, so as to load and unload. Many accidents may occur while so doing. It would be very strange if there was no obligation to insure the lorry during these incidental operations. If an accident happened while it was backing from a public road into a private drive so as to turn the injury would clearly arise out of the use of the vehicle on a road. So also if it's backing from a main road into a private road so as to load or unload it, and that is this case. So that's the foundation for this submission as we understand it. To the end of the paragraph. Yes. Yes, so that if one picks it up over the page.
Bottom of the page, I agree.
Well, he says in the fourth line, but when it is engaged in operations incidental or ancillary to a journey on a road, then any injury during these operations arises, I think, out of the use of the vehicle on a road that must be covered by insurance. Is there anything else?
And just to the end of that paragraph.
Seems that the insurance companies accept this view because I notice that all motor policies in common form cover the use of motor vehicles anywhere, not only on a road but also in a yard or elsewhere. Any other view would make a deplorable gap in our system of compulsory insurance. Now, the incidental or ancillary point was considered by Lord Justice Burkitt. In the same case, it's at 1037. Towards the bottom of the page, he disagrees with Lord Denning. The strict use of the language, therefore, is about 6 lines up from the bottom. It is plain that the accident was not caused by the use of a vehicle on the road, nor did it arise out of the use of the vehicle on the road. Can it be said that because the vehicle had to be driven along a road to get to the yard and it was driven along without any accident, and an accident occurred, that accident arose out of the use of the vehicle? And he rejects that proposition. Similarly, Lord Justice Romer at page 144, right at the bottom of the page, 4th line from the end. The argument to the contrary is, as I understand it, that the lorry could not have got to the yard if it had not been used on a road for the purpose of getting there, and that accordingly the accident in the yard arose out of that use. It appears to me that in order to arrive at this result, the language of section 36 has to be stretched beyond permissible limits. An accident is caused by the use of a vehicle on a road if it runs over a pedestrian at a zebra crossing, an accident arises out of the use of a vehicle on a road if it skids off the road and injures a pedestrian who is walking on the pavement. Do you want more?
No, no.
Now, this analysis was also considered in Randall and MIB at bundle of authorities, at it's the second bundle of authorities. It's tab 32, and it's MS 965. And briefly, the plaintiff in that case had been wishing to deter, I'm reading from the head note, wishing to deter a lorry driver from leaving a private site, stood in front of the lorry, which was stationary on the site near an entrance to the public road. The lorry was driven at the plaintiff, who jumped aside, but was hit by a wing and trapped between the moving lorry and the escarpment of the raised bank on the site. And so the issue which arose here was whether or not there was the injuries were caused by arising out of the use of a vehicle on the road. And Mr. Justice McGaw dealt with the matter at letter C on page 971. And I'm not going to read that, but can I give you the reference? Letter C down to letter H, and he rejected the proposition of Lord Dennings. Similarly, and more recently in Inman, which is in the authorities bundle 2, the same bundle at tab 26, at MS 899, the facts very briefly of this case, where the claimant sitting on a grass bank below a bank when the first defendant, who was uninsured, rode a motorcycle into her. He'd deliberately ridden along a metal path, which was regarded as a road, onto a grassy path, and then taken off at the top of the bank. Caused a collision. And the issue here is, again, was the location of the accident considered to be a road. And the Lord Justice Peter Gibson rejected the suggestion that this could be a road, and referred to Romford and Mr. Rice. It's at page 904, at paragraph 24. Where in effect the incidental and ancillary submission was being made on the basis that but for the fact that the motorcycle had ridden along the metal path, which was a road, it wouldn't have got to the point where there was not a road. And the court, Justice Peter Gibson stated, however, the but-for test is not sufficient in my judgment to establish causation. But for the use of the public road, the driver in the car and cutter would not have caused the injury that was in the car park. But that did not mean that the accident arose out of the use of a car on a road. See also Romford, per Lord Justice Burkett and Lord Justice Romer. Lady, I understand you're content to have a break at some point. I was going to deal with one other authority, if I may, before having a break.
We're in your hands entirely.
Thank you. And the next authority, the next is Omani and Jolliffe, which you'll find in Bundle 2 at tab 30, MS 942. Having drawn your attention to authorities which suggest that the scope of use is not as broad as Lord Denning would have liked it to have been, here is a further authority which identifies that use is to be given a restricted meaning. And it sees this was the Court of Appeal was considering the issue of use in the context of the obligation on the part of the MIB to meet a judgment, relying on clause 6.1c, subparagraph 2 of the Motor Insurance Bureau's Compensation of Victims of Uninsured Drivers Agreement, which is set out at page 248 of the report, MS 945, which exempted the MIB from any liability where the person using the vehicle used it without an RTA, Road Traffic Act compliant insurance policy. And well, Justice Simon Brown identified the central principles to be derived from the authorities, including at 947, letter F, using in clause 6 of the agreement of 1972 bears the same meaning as in the Road Traffic Acts, now the Road Traffic Act 1988, so that a user is by definition someone required to provide third-party cover, and if he fails to do so, is potentially liable both criminally and civilly. And that's a reference to section 143 of our Act and 1453 of our Act, 143 being the criminal provision and 1453 being the civil provision. User must therefore be given a restricted meaning. And we submit that Mr. Holden was not in any sense a user who by definition was required to provide third-party cover when repairing his vehicle off-road in private premises. And perhaps pose the question, what if his insurance had expired the day before he undertook the repair? And on that day when he was insured, he delivered his car into his employer's workshop. And then the next day, when he wasn't insured, had undertaken the repair with the intention of not taking him onto the road until he had arranged new insurance. In other words, he was uninsured by a motor policy at the time he was undertaking that repair. It could not have been said that he would be using his car in circumstances which required him to have motor insurance. And in our submission, it could not be said that the liability was one, that he was guilty of an offence. So to give the restricted meaning to user, one can have regard to the fact that he's not required to have that. He's not required to have that insurance, and would not be guilty of any criminal offence if he didn't have that insurance.
Well, is that a convenient moment?
That's a convenient moment.
We'll adjourn for 5 minutes. Well, you have until 12 o'clock.
I've got until 12 o'clock. Well, let me take you to the European authorities, because I think we can deal with those relatively quickly. The first submission that I simply make in relation to these is that they support the position that I've set out in English law. They are actually, you can see as you trace them through, a narrowing of what use actually means, a closer definition of what use actually means. And in summary, it means use consistent with the normal function of a vehicle, that's Vanook, as a means of transport. That's Andrade. And in a sense, I probably don't need to say a lot more than that, because certainly I would submit to you that repairing a vehicle is, first of all, it's not consistent with a normal function of a vehicle, but even if you were to come to that conclusion, then in my submission, you couldn't come to the conclusion that it was consistent with the normal function of a vehicle as a means of transport. And can I just give you the references in those cases? First of all, Vanook is in bundle 3 at tab 41 at 1121, MS 1121. This was primarily a case about geography and the scope of the requirement under the directive, because it involved a tractor which was off the road and had a trailer on it. It was manoeuvring, and it collided with a worker, farm worker, I think, who was on a ladder and injured him, with the result that the issue arose as to whether or not that ought to be covered. And the relevant paragraphs begin at paragraph 50 on MS 1140. Where the court states the objective of the directives being that the victims of accidents caused by those vehicles receive comparable treatment, irrespective of where in the European Union the accident occurred. And then at 52, the development of the European Union legislation concerning compulsory insurance shows that that objective of protecting the victims of accidents caused by vehicles has continuously been pursued and reinforced by the European Union legislation. And then at 56, in the light of all those factors, and in particular of the objective of protection pursued by the first to third directives, the view cannot be taken that the European Union legislature wished to exclude from the protection granted by those directives injured parties to an accident caused by a vehicle in the course of its use, if that use is consistent with the normal function of that vehicle. And accordingly, the decision, paragraph 59, in the light of all of the foregoing considerations, the answer to the question referred to in Article 3.1 must be interpreted as meaning that the concept of use of vehicles in that article covers any use of a vehicle that is consistent with the normal function of that vehicle. Then I'll take you then, please, to Andrade, which is at MS, it's at tab 38 in the same bundle. It's at page 1089. It was a case where a tractor was involved again, and at the relevant time, the tractor had driven to and stopped at a particular location where a spraying was being undertaken. The spraying equipment which was carried on the tractor required the tractor to be running so that the motive power which was required for the operation of the spray was actually derived from the tractor which was running. And an accident occurred when the spraying was being undertaken, and in short, the court concluded that that did not amount to a use of the tractor which required to be insured, because at the relevant time, the tractor was not being used as a means of transport. It was the spraying equipment which was being used.
So the accident was caused by the spraying equipment.
The accident was actually caused by a landslip, which caused the tractor to fall down the slope. But at the relevant time, the tractor was not being used as a means of transport. It was being used as machinery for spraying. Yeah. So the court drew that distinction.
This paragraph 10, I think, is the explanation of the landslide was a combination of the weight of the tractor and rain. The tractor fell down and overturned.
Yes.
Weight and the vibrations, yes. Mm.
Yes. So the tractor was clearly involved. It was running. It was providing motor power, presumably from a power takeoff or something such as that. And nevertheless, that was not regarded as being the normal function of the vehicle as a means of transport. So you can see the European Court narrowing the scope of the requirement for compulsory insurance does not simply mean any use of a vehicle. It means use where the vehicle is being used as a means of transport.
Which are the key paragraphs for the purpose of
The key paragraphs, I think, are 22.
Page?
I'm sorry.
Page, please.
1093.
Thank you.
32, 1095. 33, 34, 1095.
Well, 38 is the conclusion, isn't it?
And I was getting to that. Follows
Concept of use of vehicle
38, 1096.
covers any use of a vehicle as a means of transport.
Yes. And it's perhaps interesting that as part of the reasoning, paragraph 19, this is 1092, at the bottom of 1092, the circumstances of the case that give rise to that judgment, which is referring to Vinook, are such that it may be concluded that the normal function of a vehicle is to be in motion, which leads to paragraph 38. And then at 42 at 1096, in the light of the foregoing considerations, the answer to the first and second questions is that the first directive must be interpreted as meaning that the concept of use of vehicles referred to in that provision does not cover a situation in which an agricultural tractor has been involved in an accident when its principal function at the time of that accident was not to serve as a means of transport, but to generate as a machine for carrying out work the motor power necessary to drive the pump of a herbicide spray. And we submit that that gives you a real indication of the scope of use, and then rather narrower, more limited scope of use, which attaches to the compulsory nature, compulsory insurance and what must be required. And if a vehicle, a tractor, which has its motor power running and is serving equipment, and has been driven to a particular location so that it continues to run and serve spraying equipment, falls down a mountainside, is not to be regarded as a means of transport, then something which doesn't have any motor power, has been disabled, is on its side, supported by a forklift truck, and is being repaired, can also, in our submission, not be regarded as something which is being used for its normal function as a means of transport. There is a third authority, recent authority, which I draw to your attention, and only draw it to your attention, it's Torero. It's in the bundle, Authorities 3, at tab 40, it's MS 1111. But 11, 4 ones.
Thank you.
But it doesn't particularly help here because it's really concerned with the question of geography. But it applies the nook in the sense of accepting any use of the vehicle that is consistent with the normal function of that vehicle. So arising out of that, our submission is very clearly, at the time of Mr. Holden's incident, his vehicle was not being used as a means of transport and did not fall within the concept of use as explained by the European Court. We submit that the European decisions are of direct relevance because they interpret the word use in the directive, which of course has application in this country, and the word use is in the statute which we are seeking to interpret. There's no reason in our submission why the meaning as identified by the European Court in those 3 decisions should not guide this court. And as a result, in our submission, the Court of Appeal decision was wrong. Then I'll deal just briefly with the Commonwealth authorities. You'll see from the judge's decision that he did not regard them to be of assistance. The Master of the Rolls did not find them to be helpful and didn't consider them. It's in paragraph 67 of the judgment, where he expressly says so at MS 152. He stated that the Canadian cases did not concern the interpretation of anything equivalent to section 1453. The Australian authorities did not have to take into account the directive or the nook. Lord Justice Beatson did not consider the authorities, although he said he agreed with the judgment of the Master of the Rolls and of Lord Justice Henderson, and it was only Lord Justice Henderson who considered them. He didn't, noteworthy that in his judgment he didn't refer to the directive or to the nook at all. He didn't compare. He referred to case of Elias, which is in the authorities at 3 tab 45, page 1169, MS 1169. But when considering that case, Lord Justice Henderson didn't refer to the principal finding of the court, which was that the activity that was concerned that court fell within the scope of ownership and therefore was covered by the policy which covered ownership as well as use. The subsequent, in our submission, the subsequent finding is obiter. In paragraph 79 of the Court of Appeal's judgment, Justice Henderson referred to Piloteri, which is at MS 1209, tab 50 in bundle 3, where he referred to a purpose test which had been explained in the case of Stevenson, MS 1230. Stevenson was not a case of repair. It involved overflowing petrol storage tanks having been filled by a tanker. And the test, which was relied upon, as explained by Mr. Justice Rand Stevenson, which was set out in MS 1214, was that the expression use or operation would or should, in my opinion, convey to one reading it all accidents resulting from the ordinary and well-known activities to which automobiles are put, all accidents which the common judgment in ordinary language would attribute to the utilization of an automobile as a means of different forms of accommodation or service. Now, in our submission, whatever that means, it's not a test described by the European Court in Vinook or in Andrade, which are to be preferred. In relation, just in summary, in relation to the Commonwealth authorities, they operate under a different statutory regime. They operate with different insurance contracts, some of which include the concept and principle of ownership as a means of identifying when liability under the policy shall be determined. It's not possible to identify a thread of principle through those authorities, such as that which we see being identified in Vinook and in Andrade. We don't know the criminal background to those cases and those authorities, such as would require a more restricted meaning to be given, as in Omani, which I've given you the reference to. And lastly, so in our submission, those authorities don't help the court. Lastly, and in the few minutes that I've got left, can I deal with the issue of arising out of. And I take you to the first, to War Boys, which is tab 13 in Bundle 1. That's MS 635. Where Mr. Justice Silber was considering two questions which are relevant to to the case that you are considering. The first was whether or not the bodily injuries suffered by the claimants arose out of the use of the vehicle on a road or other public place. And the second was whether they involved the use of the vehicle. And he concluded, I'm reading from page 635 in the holding, that the bodily injuries suffered by the claimants who were in the rear of his vehicle did not arise out of the use of the vehicle on a road or other public place. And we see that developed at paragraph 58. And second, at paragraph 83, where he deals with the question of whether or not accidents involving your vehicle was the concept which, or the test which is expressed in the insurance policy. He says that paragraph 83, as to sub-issue B, the wording in War Boys policy only covers accidents involving your vehicle. I cannot understand how that could be interpreted so as to cover deliberate poisoning and sexual assaults. These words show that there was a requirement for War Boys taxi to be involved in an accident, but the deliberate acts of poisoning and of committing sexual assaults cannot be regarded as satisfying the requirement, even if they occurred in the taxi. And we submit that if the Court of Appeal was correct to reconstruct the policy so that it covered incidents involving the vehicle, that even so, one cannot say that in a relevant sense, the incident that if Mr. Warboy's activities did not involve his vehicle, one could hardly come to the conclusion that Mr. Holden's activities in welding his vehicle involved his vehicle.
Trying to get help as to what arising out of means, we've got Mr. Justice Silber apparently talking about casual concomitance as opposed to casual connection. But there's something gone wrong with the typing.
I think something has gone wrong with the typing there.
Because he's quoting Lord Justice Pill in Dunthorne,
Yeah.
and it's clear we're talking about causally concomitant.
Correct. And I think that goes back to the judgment of Lord Justice Mr. Justice Windair in New South Wales and Green, I think, where he set out the test which came to be adopted by a number of them. And there are a variety of different reports in this country of judges adopting it and mixing up causal and casual. We're not in dispute about that. And if we need to go back and look at the correct language.
Well, it clearly is causally.
Yeah.
What's causally concomitant mean?
Good question. I tried to work that one out for myself.
Very well.
But I think it has to mean, in some relevant sense, has some causal connection.
Actually, casually concomitant is easier to understand than causally concomitant.
Yes.
Very well, thank you.
And then Dunthorpe, which is at tab 23 in volume 2. MS 835.
You are out of time, Mr. Eklund.
I wasn't going to develop this in any way.
Well,
whatsoever.
just a few sentences.
Other than to say that in our submission it's wrongly decided. One can clearly see that there was real doubt in the minds of the judges in the Court of Appeal, in this case, whether Mr. Justice Law's decision had been correct, but they were prepared to accept it, that it was a decision for him. The principal submission we make is that the car in itself, the car had been driven to a non-negligent stop, and the negligence which caused the accident which occurred as a result of which Mr. Dunthorne died was simply the negligence of the pedestrian, the driver who had become a pedestrian, in the way she conducted herself in going across the road. It had nothing to do with the car. And so it's a wrong decision.
Isn't it ancillary to running a car to seek to obtain petrol when it has lost all power?
Well, you could say that, but actually what had happened here was that she'd left the car behind for 10 minutes or so, whatever she'd been doing, and she just decided to run across the road when she saw a friend who was on the other side of the road, and she ran out without paying sufficient attention.
But assuming that she was running to try and get help,
Yes.
it can't turn on the fact, but the possibility is there, isn't it?
It is
could
there.
be an ancillary function.
I agree. And I think the decision of Mr. Justice Windair that I was referring to is at page 563, and I think it's accurately reported. It excludes cases of bodily injury in which the use of the vehicle is a merely casual component, not considered to be, in a relevant causal sense, a contributing factor.
Those are your submissions, Mr. Eklund?
Thank you.
very much indeed. Mr. Vincent? Mr. Edelman?
Ladies, my lords, can I start with the construction issue? Insurance policies are invariably produced in a standard form. The standard form may be simple or complex, but one thing that all policies have in common is a very basic structure. Firstly, you get the insuring clause or clauses. Then you get the exclusions. So the insuring clauses are telling you what's covered, the exclusions telling you what's not covered. And then you have conditions, which tell you about ancillary rights and obligations. And this policy follows exactly that pattern. On page 390, you have the insuring clauses. And it's 1A, 1B, 2 and 3 and 4. And then on page 391, we have the exclusions to section A, because we are in section A. And in page 399, on page 399, we have the general conditions. So, unsurprisingly, the same standard form structure to an insurance policy that you would expect to find. And if you're seeking to ascertain what is covered by an insurance policy, the place you look is the insuring clause. You expect to find in that insuring clause section, because of course there may be more than one clause expressing the cover, but in that section you expect to find what the policy is intended to cover. And that's why both the judge and the Court of Appeal, in their own different ways, correctly focused on the correct construction of Clause 1A of this policy on page 390. It's also why Mr. Eklund correctly focused on the correct construction of Clause 1A in his submissions below. The essential flaw in the appellant's case on appeal on construction is that it starts from the premise that the statutorily required certificate of insurance is not simply, in this regard, a statutory declaration that the policy complies with the minimum requirements of the law, but is in fact operating as an additional insuring clause to supplement what, even on his own case, is a deficient and defective insuring clause. Now let's have a look at the form of the certificate itself on page 419, just to see what it's purporting to do. And one can see at the top of the page that it confirms its status. This certificate is evidence of your insurance. It's not the terms. For full details of the cover, you should refer to the policy, which is mere confirmation of what anyone who knew anything about insurance would know, that if you want to know what's covered, you have a look at the insuring clause, and that will tell you what is covered. Now, it's right to say that at the beginning of the policy documentation, in the schedule on page 381, it does say that the certificate should be read in conjunction with the policy booklet. And there's one good reason why that is the case, because when you go to the certificate, there is one respect in which it does define the ambit of cover, and that is under the limitations as to use. And it is right to say that nowhere else in the policy documentation are those limitations as to use expressed. So to that extent, I accept that the policy, the certificate forms part of the policy and controls it. But it's not purporting to say or do anything about the insuring clauses. All it does is to certify that whatever it is that might be set out in the policy is at least sufficient to satisfy the terms of the Act. But it's why, in our submission, that when one is construing this policy, one doesn't start with the certificate or even actually include the certificate at all. One might divine from the certificate the fact that one of the commercial purposes of the policy is to satisfy the requirements of the road traffic legislation, but it doesn't tell you what the overall commercial purpose of the policy is. It just tells you that that is one of them. Let's go back to page 390 and look at the insuring clauses. Consistently with what we say is what an insuring clause is doing, it is entitled Cover for You. It doesn't say please see the certificate, it's saying cover for you, this is your insuring cover. And it's plainly intended to be a statement of what the insurance cover actually is. So one then has to say, ask oneself, what the object of the exercise of construction must be. And the exercise must be to make clause 1A work as it was objectively intended to work. I recognise, of course, subjective intentions one can disregard, but how it objectively was intended to work, i.e., as expressing the scope of cover under the policy and including within its scope at least the statutorily required insurance cover. We drew an analogy in our case with what the court did in Durham and BAI, the EL Trigger case, where it was confronted with a somewhat similar problem to this case. It turns on its own facts and details, but in summary, what they had was an insuring clause which only applied when injuries were sustained during the period of insurance. And that was all right, that was sufficient to cover 98 or 99% of cases of an employer's liability, the tripping and slipping accidents, where the injury would be contemporaneous with the negligence of the employer or the employer's servant or agent that caused the injury. But it didn't cater for the 1 or 2% of cases where the injury occurred decades later, as was the case with mesothelioma. You might inhale, but you wouldn't suffer the injury until decades later. So what do? The court doesn't throw up its hands in horror and say, well, those sustain is the language used, although I was able to persuade the Court of Appeal to do that. I wasn't able to persuade this court to do it. What it does is it looks at the wider purpose of the policy to see what it was trying to do and reaches the conclusion that although the ordinary meaning of the word sustained is to actually suffer from something, and that didn't cover mesothelioma during the period of insurance, when you stood back more and looked at the policy provisions more broadly, took them as a whole, traditional approach to construction that my Lord Hodge has recently confirmed is the correct approach in Wood and Capita, one finds that that narrow meaning cannot have been intended. What must have been intended is that this would not be a policy with gaps in cover, but it would provide a seamless protection for all the employer's liability. Hence, sustained must, startlingly perhaps as a matter of language, mean caused, or be read as having been intended to mean caused, a very different word. But it gave commercial purpose to it. And the court also took into account the fact that post the 1969 Compulsory Insurance Act for employers, that would also be the mandated form of insurance. As it so happens, a chunk of the policies were pre-Act, so were construed even without reference to the Act to have that meaning. But the ones that were post-Act had the additional factor that it was, because they also had to issue a certificate, that they should be assumed to comply with the statute. And so the exercise of construction may involve, as we say this case does, reading the literal language of the insuring clause in a different way from its literal and ordinary meaning, taking into account the overall context in which those words appear, to give effect to what was the apparent purpose of the contract. And there is, on any view, immediately an obvious deficiency in the language of the policy. It is patently deficient. It's not a matter of the lawyer digging around to find some deficiency. It's patently deficient because we all know, and it's well established, that you can be liable for an accident in which your vehicle is involved, even though you're not in it at the time. You can park the car, forget to apply the handbrake, disappear off, the car rolls down the hill, it causes an accident, you are liable, and it's something for which insurance under the Act is required as well. And we can say with almost absolute certainty that the insuring clause must have been intended to cover that. But its literal language doesn't. So that's almost immediately the indication that the language has gone wrong. But there are other indications in the policy that the language has gone wrong. Let's look at clause 2 on the insuring clause. Now, it's important to note the introductory words. We also provide the cover under section 1A. So, although this is an expansive list of cover for other people, it's supposed to be controlled by 1A, as if you're substituting the other people for the insured. If that's right, then all of these bullet point covers would similarly be limited by the other person being in the vehicle. But that's plainly not what is intended. Hence, it's not just drive your vehicle, but the second bullet point, use or drive. Use but not drive. Now, my learned friend said they can be sitting in your car having a cup of coffee, or you've answered affirmatively to that. But we know from the authorities that you have to have control and management of the car to be a user of it. So merely sitting having a cup of coffee as a passenger isn't enough. You have to be someone who has the operation, management or control of the vehicle. And the fact that it's contemplating using but not driving suggests that the draftsman has in mind someone who may have parked it outside their house, a car lent to a friend for a day. They've driven it, fortunately without incident, and then they've parked it outside their house. By parking it outside their house, they are using it still. And it's plain that this clause 2 is intended to cover that, but its preamble, section 1A, would be contradictory with that. But it also sets up another tension with the literal language of 1A, because let's assume that the draftsman wasn't intending the cover under 2 to be limited to when the other person is in the car. It would mean that they were actually giving broader cover to other people than they were to the insured. If one didn't read 2 as subject to 1A, it would mean the insured's only covered when in the car, but other people covered when they're not in the car, which is a complete nonsense. It's nonsense to be giving broader cover to other people than the policyholder himself. And then we've got bullet point 3. If you're getting out of the vehicle, you have to be in it to get out of it. But getting into it, you're not in it. And so we know that both points apply again. Either making it subject to cover under 1A is wrong, or it can't be intended in 1A insofar as it results in narrower cover for the insured than it does for other people, because in your vehicle wouldn't cover getting into it. And the fact that the policy is not focusing on actually being in the vehicle, which is demonstrated by 2, is also shown by the concept of use being used elsewhere on page 398. We look at the general exceptions to all these sections. You are not covered for any of the following. Who uses your vehicle? Again, the concept of use coming in, not being in the vehicle, but use. Will not cover any injury, loss or damage which takes place while your vehicle has been driven or used by anyone not allowed to drive it, or used for any purpose. Again, used for any purpose not allowed by the certificate. And after the second bullet point, this exception will not apply if your vehicle is with a member of the motor trade for maintenance or repair. And under 7, we will not cover damage or liability caused by using your vehicle in any area where aircraft are normally to be found landing, taking off, moving or parked. So it's use again of the vehicle as a concept in the policy as a whole. And you'll see that they chose not to exclude use by the motor trade, but I'll leave that till later in my submissions. As in...
Well, I mean, one thinks, so, well, this might be relevant, but then one looks carefully at it. One, who uses your vehicle? The exception is for people when they're driving. And so the exception doesn't apply if your vehicle is with a member of the motor trade. So the exception doesn't apply when the vehicle is being driven by a member of the motor trade.
Or used.
Is that right?
Or used. Well, the exception the exception doesn't apply if your vehicle's with a member of the motor trade, so they are not an excluded class of person. So someone in the motor trade falls under insuring clause 2, is the answer. They are a qualifying person. And what the policy draftsman no doubt had in mind is you might give your car to a motor repairer, not give anyone any particular permission to use it, so they are someone who's not been allowed by you to drive it, but nonetheless they fall within the cover under insuring clause 2 for other people. So a motor repairer is covered for using or driving.
In clause 2, which bullet point in clause 2 would that apply to?
Well, it would be anyone you allow to use but not drive, and anyone insured by this policy to drive, that's a named driver, anyone you allow to use your vehicle. So they are using it, and that in a sense is suggesting that they do. I'll come on to that.
Well, that begs the question about whether use includes repair. So
yes, of course. Yeah. At this stage of my submissions, all I'm focusing on is the fact that the policy has the concept of use. And it's almost as if it's contemplating that the insuring clause, despite it saying in your vehicle, is covering something broader. So it's my contextual construction submission. Now, it's right to say, of course, as in the Durham and BAI case, the vast majority of accidents that will involve a car will be road traffic accidents. Don't shy away from that. That's the core element of the cover. But as in Durham and BAI, the fact that you may have, in that case, 98 or 99% of cases covered by the insuring clause doesn't mean that you can then say, well, that's good enough. Because the intention must be that this wasn't intended to be a partial cover, and that we say is self-evident from the other provisions. But if one does apply the literal construction of 1A, we have a gap in cover, and secondly, we would submit internal inconsistency with other provisions of the policy with which it was supposed to operate.
When you say gap in the cover, that's the gap required to deal with the Road Traffic Act.
And it's also the gap as compared to the cover for other people.
I understand. Yeah.
It's not just the statutory gap, it's a nonsensical inconsistency, a gap in cover as compared to, for example, the cover for a passenger. Now, added to that, we have a patent error in the wording of clause 1A itself. And if one goes to the bullet points in 1A, one can see that the cover for damage to property or vehicle is, on a literal reading of it, conditional on the property or vehicle being that of the person you have injured. Quite tellingly, although the appellants seek to rely on the literal meaning of the preceding language, they have not had the temerity to seek to rely on the literal meaning of this part of the clause to deny liability on the basis that the owners of the damaged properties were not killed or injured.
But it doesn't necessarily mean that. You damage someone's property. Or you
Well, it
damage
says-
someone's vehicle.
Someone's, yes. If the word someone's had been in place, I accept that's entirely...
You say there refers back to the someone in
Yes.
bullet point 1.
If you're reading this in the ordinary language, you kill or injure someone, you damage their property, you damage their vehicle.
It
The
simply
there should have been someone's, and it's obvious.
Well, you kill or injure a person, you damage a person's property, you damage a person's vehicle.
I quite understand that's how one makes sense of it, but in fact, that's not what the language literally used says. Now, that's not a mere forensic point. It is of substantive relevance because it's the clearest possible indication that this is not a carefully drafted provision, seeking to set out clearly defined demarcations of the insurer's liability, but rather, I'm afraid to say, a rather sloppy piece of work.
But it's the tension between plain English on the one hand, simplification on the one hand, and precision on the other. Insurance policies, insurers are always being pressed to make their policies simpler.
They are, and sometimes, and this is a case where they have, as a result, made mistakes and obvious mistakes in the language they have used.
Yes, I see that.
It wouldn't have taken much attention to the text of the clause to realise that in those the second and third bullet points, the word there should be replaced with the word someone's.
Yes.
And that's the obvious sense of it. And my point is...
You can readily construe it that way. Yeah.
You can readily construe it that way. But my point, my submission is that not only was this misdrafted in the first place, but someone obviously hasn't read it through to see if it makes sense. And if you're at that level of error in the language, you then begin to wonder how much credence you can actually place on the literal language that the parties have, that the insurer has used to draft this policy. And it's hardly a promising start for treating the words in your vehicle as sacrosanct, as my learned friend has sought to do. So if we assume, and I think there's probably common ground about this, that, but I'm not sure, maybe not common ground as to the route, but certainly I would say common ground as to what the net result should be. It's common ground that the cover under the insuring clause was not intended to be restricted to accidents occurring when the insured was in his vehicle. What can we glean from the policy as a whole as to what its intended ambit was? Is it merely to be topped up with the minimum statutory cover, as the appellants contend? Our submission is such an approach would again fly in the face of all the other indications in the policy which demonstrate that cover well beyond the ambit of the statute was intended. Firstly, there is the lack of any geographical limitation in the insuring clause. On the correct premise that the vast majority of motor accidents will occur as a result of negligent driving, it's quite apparent that the appellant was giving cover for driving accidents, whether on private land or on a road or in a public place. Secondly, point I've already alluded to, the scope of cover under Clause 2 for other people, for other people's use of the motor vehicle and for passengers getting into and out of the vehicle, likewise not subject to any geographic restriction. In particular, cover for passengers is not required, even if they're getting into and out of a vehicle on the road, because that doesn't qualify as statutory use. That's the Brown case. On page 391, we can see in the 5th bullet point that the limit on liability for property damage is 20 million. Well in excess of the statutory limit, which they have been putting up gradually, but even now is only 1.2 million. Next point is when the draftsman wishes to invoke minimum statutory requirements, this is done so expressly. One can see on page 391, in the penultimate bullet point, in the exceptions, there's an exception for liability caused by acts of terrorism, unless we have to provide cover under the Road Traffic Acts. That's the penultimate bullet point on the left. On page 397, the cover for use abroad. Under B, it also provides the minimum cover you need by law to use your vehicle in other countries in the European Union. Again, specifying the minimum cover when that is what the policy intended to stipulate. And then 398, there is the war exclusion, clause 4, and again, unless we have to provide cover under the Road Traffic Acts. So the draftsman was well aware of the existence of minimum statutory requirements, imposed them where appropriate, but clause 1A is silent as to any reference to or qualification by those statutory requirements. And then looking more broadly other factors to see what this policy is doing. Because my own friend is treating this policy as if it was there to provide just maybe a little bit more than the minimum statutory cover. We've already seen ways in which that was not so, cover for passengers, cover for 20 million of property damage, but we can see that more generally this is a much broader policy. It provides pages 391 to 392, it covers first party loss, damage to your car, it covers on 392 fire and theft, it covers windscreen damage, also on 392. And then at 395, it provides some additional benefits, personal accident cover. And on 396, a whole range of other covers, medical expenses, personal belongings, hotel expenses, new vehicle cover, child car seats. So the suggestion that the insuring clause should somehow be read in the most restrictive way possible, just so as to give it the bare minimum in addition to the insuring clause, as it expressly stands, which is what the appellants say, is...
But how does non-third party cover inform us about the extent of third-party cover. I don't see any
What
necessary connection.
What it's telling you is that this, contrary to what Malone Friend says, this is not merely a policy that is issued to satisfy the statutory requirements.
No.
This is a policy that is ensuring you against things associated with your ownership of a motor car.
Ah.
Of course, the core cover for that is liability. That is a statutory required element. But it's covering you for your everything associated with ownership. That includes first-party losses and consequences, as well as third-party ones. And that's part of the context in which this appears. When you're looking at Clause 1A and you're seeing how generous this policy is in providing cover for things associated with ownership of the vehicle, why should one adopt an unduly restrictive approach to the construction of Clause 1A?
So what happens to the word in Clause 1A? Do we chuck it out?
Involving.
Involving.
And that actually is the word that is most consistent with the whole structure of the policy, what the policy appears to be doing. But it's covering you for the consequence of being a car owner. It also ties in with the fact that the house owner's public liability policy will contain a blanket exclusion, and Churchill's own policies did, a blanket exclusion for anything relating to the ownership of a motor vehicle.
It is as broad as that, anything involving the car. All of these other provisions that you've taken us to wouldn't be necessary, or at least many of them wouldn't be necessary.
I don't know which provision, my lord.
Well, you've taken us to all these other provisions where the benefit, where the liability is extended and the particular benefits are provided, which you say indicate that one should give an expansive interpretation to the policy as a whole.
Those are first-party losses.
Yes.
Those additional ones are first-party. What we're dealing with here in 1A is the liability cover, third-party cover. So
I see.
The word involving doesn't impact on any of that at all.
Right.
Because this is just covering you for your liability to third parties under 1A.
Yeah.
All the other bits there's nothing to do with any liability at all. It's just saying, well, you're the owner of a car and your car could be damaged. You could have personal accident expenses. The child car seats in your car could be damaged. You might have to stay in a hotel if your car it can't be driven after an accident or loss covered by the policy. Your car may be stolen. All of those are first-party losses.
Yeah.
And, of course, cover for damage to the insured's car, if you go back to that, if we look at those first-party benefits, page 391, if your vehicle is damaged, it says nothing about the insured having to be in the car when it's damaged or somebody else having to be in the car when it's damaged. It doesn't specify where the car must be when it's damaged. The cover would encompass damage to the car resulting from it being negligently parked without handbrake on in a dangerous position or by negligently opening the door to get in it.
I'm sorry, which exclusion are you looking at there?
Now, I'm looking at the cover for damage to your car on page 391, my lady.
Well, 391.
Yes,
Right, thank you.
damage to your car.
Thank you.
That's the first party damage cover. And if the damage to the car doesn't require the insured to be in it or isn't restricted in any way, why shouldn't the owner's, the insured's liability be equally expensive? And this is a contextual construction point. It's just merely looking at the generosity and breadth of the cover and then saying, well, what consistently with what this policy looks as though it's trying to do is a construction of 1A that is consistent with the overall context. And funnily enough, the actual language involved is used for the child car seats cover, not the most significant of the covers, I appreciate, but 396. If you have a child car seat fitted to your car and your car is involved in an accident, damaged by fire or theft or stolen and not recovered, we will cover for you the cost of replacing the child car seat. So, subject to my friend's submissions about whether this car was involved in an accident, even though it was actually the seat of the fire, we'll come back to that. If a child car seat had been in the car at the time, the test of whether the vehicle was involved in an accident would be the test to be applied as to whether or not there was insurance cover for the damaged child car seat.
But that is an additional benefit, isn't it, Mr. Edelman?
Yes, quite.
So we can't say, oh, well, they clearly mean involved in
Nope.
1A.
Nope.
Because this is an add-on.
Yes, quite agree.
Well,
I'm not pushing the point too far. All I'm saying is that this is a concept that is used, involved in the accident is a concept the draftsman had in mind. But when one stands back, is one not looking at this and seeing involvement of the vehicle in a number of respects in all these covers? So we say the cover was intended to be a broad and generous one. It was provided under a well-known insurance label at Churchill. They also provided home insurance, which would have included in its public liability insurance cover an exclusion of the type to which I've referred, an exclusion for anything to do with a vehicle. And that would make sense that their motor policy. It was before the court at first instance, and is referred to, and I had it, but it's referred, no, I think the home insurance is, it's on the web. The other policy wordings is, but
where will I find it on the website? I'm looking.
Churchill website, well, I've got a print out of it here. Show it to you. Taking it down, where is it? It's here somewhere. Yeah, it is.
Got a lot about the cover, but I don't have anything about the exclusions.
It says, you're not covered for any liability relating to you owning, keeping or using any vehicles.
Any liability relating to?
Yes, you owning, keeping or using any vehicles. And that's very standard in public liability insurance, because the last thing they want to do is pick up anything associated with motor vehicles. And what we would say fits the bill, and it would fit with a commercial package that the insurer was offering, is saying, well, yes, we know, ordinary member of the public, if you're lucky, you'll have a house that you are living in and can insure. And if you're also lucky, you'll also have a car. Most people do, a lot of people don't, but most people do. And if you do, you will be insured under one policy or the other for anything unfortunate that happens to you as a result of your ownership, either of the house under the household policy or a car under the motor policy. And we say that message is loud and clear from the terms of the policy, and it's unsurprising, bearing in mind that a car is such a hazardous thing, and it's being put into the hands of ordinary members of the public. It's a hazard not just when it's being driven or left somewhere, but also, unfortunately, when it's being tinkered with, especially by laymen. And the substitution of involving for in, firstly, it fits linguistically, that's all one has to do, but it also precisely fits the commercial purpose bill. And I'm not using, I use the word deliberately commercial purpose bill. I'm not just saying fits the bill because it would be jolly good. Although I'll come to whether that is a legal basis for saying jolly good makes it the right answer.
The commercial purposes bill, that's really just a reference back to the generosity, is it?
Yes, the scope, the scope of the policy, that it appears to be looking to cover everything that might be associated with the ownership and use of a motor vehicle, both first party and third party. Now, there's been unanimity, in fact, amongst the judges below that the insuring clause in this case cannot be read literally. And Mr. Eklund, at least at first instance, accepted that the word in could not be read literally because it must have been intended to cover the insured when he wasn't actually in it. And that's recorded in the first instance judgment of His Honour Judge Waxman at paragraph 27 of his judgment. Now, the solutions adopted in order to resolve this this problem did differ. As you know, obviously, the Court of Appeal simply substituted the word involving for in, which, as I've said, does least violence to the language, and had the added attraction of reflecting prior and subsequent versions of Churchill's own motor policy, where they had used the word involving, and that was in the skeleton argument at first instance. Now, His Honour Judge Waxman at paragraph 23, it's page 163 of the bundle, at the top of the page 163, says, a better wording would be if there is an accident involving your vehicle, but at this point one needs to take account of the words used in section 1453A of the Act. This refers to liability for damage, etc., caused by or arising out of the use of the vehicle on a road, and clause 1A must comply with this. 2 points on that. Firstly, why must one take into account the words of the statute? This is an exercise in the construction of a contract. A contract where the draftsman has deliberately chosen in the insuring clause not to use the statutory language. So why take that into account at all? It only comes into play if you're satisfied that the commercial purpose is only to provide a little bit more cover than the statutory minimum. But there's no warrant for that assumption as to commercial purpose. But the second and also important point is that he appears to be implicitly accepting that substitution of the word involving is at least an appropriate construction, albeit that he prefers the other construction. But in fact, that is not in accordance with the correct approach to the construction of consumer contracts. And if I can invite your attention to your First Authorities Bundle, tab 7, page 520. And these are the regulations that were in force at the time. It's now the Consumer Protection Act 2015. But it's Regulation 7. This is the plain and intelligible language provision. That's at 521. And these apply to insurance contracts as much as to any other contract. And it says if there's any doubt about the meaning of a written term, just pausing there for a moment, the European authorities establish that this requires not just formal grammatical intelligibility, but also clarity as to the practical consequences for the consumer. If there's any doubt about the meaning of a written term, the interpretation which is most favourable to the consumer should prevail. Now, if the learned judge was identifying two candidates for the meaning of this clause, and he was considering them both to be potentially appropriate meanings, his duty under Regulation 7.2 was to select from the potential meanings the one which was most favourable to the consumer. He couldn't approach, not allowed to approach it, like as he might do a commercial contract, and say, well, that one might be the most favourable, but on balance, I think I prefer this one. You can't do that. You've just got to say, well, that is the most favourable. If it wasn't, I might have preferred the other one, but it's tough. I've got to adopt this one. He obviously had concluded, and was right to conclude, that there was doubt about the meaning of this insuring clause, because it wasn't really in dispute that it couldn't mean what it said. So that's why the judge ought to have found involving, even if one assumes that his alternative construction was also an available alternative, which, for the reasons I've given it, was a wrong approach, because he shouldn't have started with...
The Court of Appeal referred to this paragraph and took involving from it.
Yes, they did.
But the use of the word involving by the judge is a word that he is using to try to encapsulate the idea that the accident was caused by the vehicle.
Yes. That the vehicle itself,
yes, because
not caused by, but
well, I'm reading.
Yes.
Read the second
Yes.
sentence of paragraph 23. It's accepted that first sentence in the vehicle is too narrow. The policy will respond if there is an accident caused by the vehicle, even if the insured isn't in it or driving. And then he gives the examples of the car rolling down the hill or being parked in a dangerous place.
But it's not caused in the sense of proximate cause, because the proximate cause, so far as the liability of the insured was concerned, would be not applying the handbrake. So when one says it's important not, caused is an ordinary English word and we're not applying a legal tag to it. A vehicle is an inanimate object.
Yes.
It can't be legally liable in itself for anything. So when he's talking about the vehicle causing the accident, what he's saying is damage has been caused by the vehicle colliding with something. In this case, damage has been caused because the vehicle was set alight, its upholstery internally was set alight, and once there was a fire in the car, that spread. And it's exactly the same analogy as the car rolling down the hill. The car, in that sense, has caused the fire. But if you're looking at liability, the liability in the parked car case is not applying the handbrake. In this case, it's the negligent welding. But we say in any event, the substitution of involving for in does, as I said, does fit the bill. It fits in linguistically and consistently with other provisions, and it's the most favourable construction for the insured in circumstances where the meaning of the clause is open to doubt. And I've got a couple of minutes, so can I just start perhaps on geographical restriction, because that's all I wanted to say on the primary construction issue. And but that construction of the clause would make it unnecessary to consider any separate issue of geographical ambit. But given the way Malone Friend puts the case, it's necessary for me to address that topic.
But just concluding on involving, it still must take its meaning from the rest of the policy. The word involving doesn't have an abstract meaning. It's a contextual meaning to be implied.
Well, there's not much other context for it to take.
But you'd agree with the principle?
I agree with the principle, but if one again is applying that contextual principle, again, the context would encourage an expansive approach to the meaning of that clause. It's supposed to cover anything that arises from the fact that you are a policyholder who owns a car. And it could be tinkering with it, but it's your liability cover. And it's fine to say, well, the statute requires something much narrower, but the fact that the statute requires something much narrower doesn't mean that that is all that insurers are giving.
May not be the owner, may he?
May not be.
May not be the owner. I noticed you focused it on ownership.
Yes, they're the keeper, registered keeper.
Well, we've now reached
Probably
the
has used up
time.
my time. That's fine, because I
So
didn't.
we'll start on geography at 2
Yes,
o'clock.
we will.
And I must warn you that it's essential that we finish at 3:30.
Yes, well, that suits me too as well for other commitments.